So a federal court just expedited review of the ATF's new pistol brace rule, and that court set a decision to be made by March 24th. So let's talk about this. But real quick before we jump into this video, if you think the ATF needs to be abolished, go ahead and hit that like button and subscribe. Also want to thank everybody who subscribed to the channel. You all have been absolutely amazing. We are rapidly approaching 500,000 subscribers, which I never thought would happen. Never in my wildest dreams did I think 500,000 subscribers would ever happen. So thank you guys so much for all of your support. And if you're not currently subscribed to the channel, please consider subscribing. It really does help the channel. It helps to push the channel more in the algorithm and signals to the algorithm that you guys see value in these videos. But regardless, thank you guys so much for all of your support. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation both at a state level and a national level while serving as a staff attorney with the Firearms Policy Coalition legal team. My goal with these videos is not to provide you any legal advice, but instead to help you understand what's currently going on in the battle for our right to keep and bear arms. As I mentioned in the intro, in this video, we will be discussing the ATF's new rule on stabilizing braces, their new pistol brace rule, which was published on January 31st, and currently there are multiple lawsuits attempting to stop its enforcement. This new pistol brace rule makes it so that almost any pistol with a brace attached to it will be considered an SBR and therefore subject to the NFA's restrictions. In response to the final rule being published, multiple lawsuits have been filed against that rule. The lawsuit we will be focusing on in this video is called Watterson v. ATF. This lawsuit is filed in the Eastern District of Texas, and it is a direct challenge to that ATF pistol brace rule. In the Watterson lawsuit, the plaintiff is seeking for the final rule to be found invalid under multiple different theories. The plaintiff asked for the court to enter a judgment finding that the ATF lacks authority to promulgate this rule, that the rule violates the Second Amendment, and that AR pistols with braces attached to them can never be considered to be SBRs, even under the NFA and the GCA. The plaintiff also requests that a postponement be entered by the court here, halting the rule from going into effect before this effective date, and also that a preliminary injunction be granted outright, halting the enforcement of this new rule from going into effect, at least while this case is making its way through the process. And most importantly for this video, the plaintiff is also requesting that the court here expedite that review and actually make its decision before this rule goes into effect, and even more so before the 60-day time period runs when the ATF says that they can enforce this rule if they want. In the lawsuit, it's alleged that the final rule on pistol braces violated the Administrative Procedures Act, and that even if it didn't, it's still a violation of the Second Amendment. In this section, the plaintiff argues, not only does the rule violate multiple provisions of the Constitution, but it also exceeds defendants' statutory authority. Even if Congress could constitutionally abdicate its legislative power by delegating power to the executive branch to create new felonies, which it cannot, it did not do so here. In issuing the rule, defendants redefine statutory provisions and expand criminal liability. However, they lack statutory authority to do so. Then you see a really important argument pop up for the first time in this APA section, and in this section the plaintiffs point to the Supreme Court's recent decision in West Virginia v. EPA. They state, moreover, defendants made critical policy decisions regarding public safety and the right to keep and bear arms when issuing the rule. Because such policy decisions are of great political significance, Congress must, at the very least, speak clearly to assign ATF this important policy-making power. Although Congress was required to speak clearly, here it failed to do so. None of the provisions on which defendants rely clearly give defendants the authority to decide to redefine rifles to include pistols equipped with stabilizing braces. So that's an important argument that is now being used and being presented here in this case. The West Virginia v. EPA decision by the Supreme Court implicated something called the major question doctrine, and when essentially deference should not be granted to an agency like the ATF under Chevron, instead maybe something else should be done. In the West Virginia v. EPA decision, the Supreme Court found that under the major question doctrine, there are extraordinary cases in which the history and the breadth of the authority that the agency has asserted and the economic and political significance of that assertion provide a reason to hesitate before concluding that Congress meant to confer such authority. When a case involves something like that, the agency like the ATF must point to clear congressional authorization for the authority it claims. Here, the argument is that the regulation of brace pistols as SBRs is of great political significance, so the ATF must show clear congressional authorization to do this type of action, which of course they cannot. The plaintiffs also argue that the pistol brace rule is a clear violation of the Second Amendment in their complaint. In this section, they argue, history and tradition do not support the rule's restrictions on a person's right to keep and bear arms. Defendants fail to show that pistols with stabilizing braces fall outside of the Second Amendment scope because they are dangerous and unusual weapons. Indeed, ATF itself has estimated that between 3 and 7 million affected stabilizing braces have been sold from 2013 to 2020, and yet defendants point to only 2 incidents where criminals used stabilizing braces in the rule. This demonstrates that pistols with stabilizing braces are not unusual or dangerous, and the overwhelming majority of pistols with stabilizing braces are being used for lawful purposes. Pistols with stabilizing braces are in common use by law-abiding citizens and fall squarely within the Second Amendment's bounds. They finish this section by arguing, moreover, there is no long-standing historical tradition that justifies banning a pistol because it has a stabilizing brace or requiring a person to register a pistol due to a stabilizing brace. So those are the arguments presented by the plaintiffs in this case against the ATF and the new pistol brace rule. The plaintiff then sought for the court in this case to expedite review of their lawsuit before the ATF can actually take enforcement actions under this rule. In the motion, they seek expedited consideration of the case, or in the alternative for a preliminary injunction to be granted, and they are requesting that the court review the case by March 2nd of 2023. The concern is that the ATF indicated in the rule that they can and may start taking enforcement actions 60 days after the publication of the rule. The compliance deadline is 120 days after the publication, and ultimately that ends up being May 31st of 2023. But the ATF gave themselves power to enforce after 60 days. So the plaintiff wanted a decision on the relief by March 2nd before the 60-day period is actually up. Well, the court denied the March 2nd deadline, but still expedited its decision and set it for March 24th. The court in their order stated, the court will issue an order on plaintiff's motion for relief under 5 U.S.C. section 705, or alternatively, for a preliminary injunction on or before March 24th, 2023. If the court finds a hearing is necessary to decide plaintiff's motion, it will notify the parties. So we know at least one court will decide whether or not to halt the pistol brace rule, its effectiveness on or before March 24th of next month. This is definitely a case we will be keeping our eyes on because March 24th is going to be an important deadline. And again, the court has said that they will decide whether or not they will issue some sort of relief. Will they grant a preliminary injunction on or before March 24th? That is going to be the question now, and that is the deadline we will be looking forward to. There are other cases we'll be watching, like the GOA in Texas lawsuit, the FRAC in 25 state lawsuit in North Dakota, and also the FBC lawsuit. But now we have at least one date, one deadline in another case, which is challenging the ATF's pistol brace rule. So if we get any more information, I will let you all know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.